Thank you. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. He is present together with his counsel. The state's attorneys are present, and the defense team is also present. The jury has a question, as I indicated on the telephone with counsel. The question is it Utah law that the surviving spouse inherits the estate regardless of what a last will says? Counsel, Mr. Spencer, can you refresh my memory? When Alexis Summers was on the stand, did you question her regarding the dispute over the family home?
I questioned her regarding her civil suit. I believe I asked one or two questions about
Could I see it? But there wasn't any reference to the family home? It was just a civil loss? Okay. That was my recollection. I've also gone back to my notes. My notes indicate that when Rachel MacNeill was on the stand, she said that that around Easter 2007, the defendant reviewed his will. She said he wanted to go over everything in his will with Alexis, Michele MacNeill, and Rachel. And then my notes from Alexis only indicate, and that's at about the time the $5,000 gifts were given. And Alexis talked about the $5,000 gifts, but I don't see anything in my notes on direct or cross about the will issue.
Well,
and so,
if I could add to the record on the Rachel issue, if you recall, I objected because I was afraid she was going to bring up the fact that her mother said, "What about me?" And we approached the bench, and I said, you know, Rachel's kind of a loose cannon. I was concerned about that, and she spit it out anyway. So I think that that's where that's coming from.
she said what anyway? I'm sorry.
What did Rachel say?
Right.
Rachel said that Michele was present during the conversation about the will, and Michele piped up and said, well, what about me? Meaning that Martin was dishing out gifts, and why was he leaving Michele out of the equation?
I thought the what about me question was in reference to why am I not the executor?
It could be interpreted that way, I guess.
That's my memory, Your Honor.
That it was in the context of Alexis being appointed executor, and she was saying, well, why is that? This is after my review of the notes, let me just propose an answer, and I welcome your input on this. During the trial, you heard evidence that around Easter in 2007, the defendant reviewed his will with Rachel MacNeill, Alexis Summers, and Michele MacNeill. The state offered this evidence to prove motive and intent and for no other purpose. You also heard evidence that Alexis and defendant were involved in a lawsuit about the family home. The defendant offered this evidence to prove bias, prejudice, and motive to fabricate and for no other purpose. The legal effect of the defendant's will and the outcome of the civil lawsuit are not relevant to this case.
May I be heard, Your Honor?
Yeah.
Counsel, we've all talked about the situation. I think it's been our experience that most often when a question comes from the jury about the record with respect to facts, that we normally refer them to their memories and notes, and then when it comes to the law, we refer them to the law that they've been given. Given the complexities of this, in addition to, I think, the issues that arise in giving the jury the facts, we would prefer that kind of approach in referring the jury to their memories, notes, and the instructions, as opposed to wading into this.
Well, and let me tell you, I'm of the view that saying less than more is better.
Sure.
I'm trying to propose an answer. I'm not particularly comfortable with it, given the dispute about the facts and the interpretation of those facts. So I frankly am more comfortable with that, but I wanted to propose an answer that is responsive to the question. So,
Mr. Perkins reminds me as well that there was some discussion with the witness Roma Henry about needing to change the home back into his name.
yeah.
And so there's just this,
And there may be even more.
and there may be more that was discussed throughout the trial.
And there was also impeachment evidence in relation to when that discussion occurred. We presented the check that was actually dated March 31st rather than Easter.
Yeah, yeah. So what do you propose?
I agree that we should just refer the jury to their memories and indicate that the law
It's irrelevant.
relevant to the case is contained in the jury instructions.
Sure.
Something to that.
I think that's the safest. I think it's best for the record, and as far as wading into these issues,
I would prefer not even to reference their memory, because the question asks about the law. Is it Utah law that? So what about an answer that just says the law relevant to the case is contained in the instructions?
I'm fine with that.
And that way they can assign whatever motive, bias, prejudice they want to the facts as they remember them. Is that
I think
fair?
that's appropriate, Your Honor.
I agree.
Okay. I will write an answer that says the law relevant to the case is contained in the instructions, in the closing, and well, I gave preliminary instructions, so in the instructions. And that will be it. Anything else now?
I think that's all.
I appreciate your collective thinking on this. I am of the view that less is more when it comes to these answers. They have the evidence and they have the instructions, and so I think,
I've had experience where the jury's been instructed on the facts, which has resulted in motions for arrest of judgment, new
Yeah.
trials, and so forth. So
I appreciate your collective wisdom on that. Anything else now?
don't believe so.
Good, thank you. Court's in recess.
All rise.